in the law says, here are the purposes of the law, which most statutes start out with as some statement of what Congress is trying to do in a statute. And Congress was pretty specific in saying what the goals of special education are, and they are to prepare kids with disabilities for success in 3 specific areas: employment, further education, independent living. Not coincidentally, the same things we're trying to do for non-disabled kids. We want kids with disabilities to aspire to the same goals, that they're going to be able to get jobs after they graduate, they're going to be able to go on to some further skill building activity, whether it's in a 4-year university or a sheltered workshop. It's something that's going to allow them to continue to develop their skills, and we're going to try to get them as independent as we can, and maybe even out of the house. That would be wonderful, and living on their own and supporting themselves, which is pretty cool too. So everything, whenever a question comes up in my mind about whether or not, parents ask this question all the time, like, am I entitled to, or can I get, can I get from a kid X, whatever X is. And now the first thing I do is go to that question of, is it something that's going to help the kid after graduation with employment, further education, or independent living? If it is, I don't want to say you can automatically get it, but you certainly have a good argument, a good issue that you can raise at your next IEP meeting to ask that be included. And if it's not something that the district's going to agree to, you can at least have a discussion about it, which is the whole point of the IEP process, is to bring you guys together with the geniuses, and I'm not being sarcastic, it sounds like that. The geniuses that know how this stuff works from doing it year after year. So the way that we make sure, try to make sure that kids are going to be successful after graduation in those 3 areas is by giving them free, appropriate public education in the least restrictive environment, which is the main mandate of the IDEA. Free, appropriate public education is special education related services that are provided at no cost, delivered pursuant to an IEP, which we will get to, I promise, and designed to meet the unique educational needs of the student. The question of appropriate, that's not easy, is it? And that's where we have the issues. If we're going to have an issue with the school district, and we're going to think that something's appropriate that they don't, or they're going to think something's appropriate that we don't. Otherwise, like I said, I go out of business and do corporate law, which would be horribly boring. But maybe I get a private jet, fancy. Be able to buy a tie. That would be cool. So the definition of appropriate is always evolving. It's very case specific, very individualized to each kid. So there's no black and white answer to whether or not a kid is or isn't entitled to a given service. But what we're trying to do is provide an IEP that's reasonably calculated to allow the student to make significant and meaningful educational progress. So progress is the currency that we're using. That's the language we're going to be talking in special ed, that we want kids to develop skills. We want them to progress in what they can do. And that's how we're going to measure whether or not an IEP is or isn't standing up to the legal standard that Congress set and that the courts hold school districts to.
Can I ask?
Yeah.
How do you feel about the word also significant progress?
Yeah, it's one of those words that lawyers
like
love.
Appropriate. It's hard.
Yeah, right. Significant and meaningful. They're great for us, for attorneys, because it gives me the ability, for example, for a kid with autism whose behavior. This is the example I often use when people ask, how do we figure out significant, meaningful? If a kid with autism has behavioral issues like out the wazoo at home, but is behaving appropriately in school, the parents are going to say, help, give us some behavioral supports in the home or after school or whatever. And the school districts don't want to breach that wall of what they can do or have to do or required to do versus what parents and other agencies are responsible for doing. And it's a crappy situation for everybody, I think, because you're not given enough money to do everything for everybody, obviously. But the budgets are just so tight. And in that situation, I get to argue, because I'm the parent side guy, that if the child's not able to behave appropriately in the home and community, then whatever he learned in school isn't appropriate. I'm sorry,
it's not generalizing. Well,
right,
and it's not meeting the goal of employment.
Right.
Yeah, I know.
Yeah,
There's a lot of ways you can
there are plenty of school districts that take the position that if the student's okay during the school day, then they don't have to worry about the out-of-school behavior. And our argument would be that it's not meaningful if he can only behave appropriately with the very structured behavioral supports that are available in school. But school districts argue back to me all the time that their obligation is to allow the kid to make it through the school day, and after school, before school, those are the responsibilities of parents and DCF, Department of Children and Families, which doesn't step up.
Right.
Kind of we get calls all the time from parents trying to figure out what agency to go after, and you're going to hate me for this, but we always target school districts because parents have an entitlement to special ed services. The DCF stuff isn't an entitlement, so we're going to go after the places that are more guaranteed to get us results. And while we're on, just real quick, the thing that's missing here, which you're very likely tuned into, is the interagency cooperation. Because I do this in Pennsylvania, I've done some in New York, I've done Wisconsin, New Hampshire, Vermont, Florida. Every other state I've dealt with has greater systems in place to provide services through a variety of agencies instead of just school districts. And I think the best, Wisconsin's the best, but Pennsylvania's got this great system that the Medicaid, all kids are eligible for Medicaid in Pennsylvania, all kids with disabilities, regardless of how much money they have. In New Jersey, you have to have very low income and low assets. The family has to have low income, low assets to get Medicaid. And then Pennsylvania uses that Medicaid money to give kids, sometimes up to 40, 50, 60 hours a week of one-to-one behavioral support in the community and other stuff outside of the school day. And that's great, it's the
Commonwealth, it's a beautiful thing.
What's it?
It's Commonwealth thing. There's many things that they get in Pennsylvania that I'm astounded.
Yeah, so, and on that note, I don't want to take too much time. New Jersey's modeling itself after Pennsylvania in a lot of ways. The judges here are spending a lot of time going to conferences provided by hearing officers there, because Pennsylvania gets special ed cases done lickety-split. They're usually done within 4 months. Anything you've been involved with has been probably years. These things just drag out in New Jersey, but there might be a light at the end of the tunnel. So I think that interagency thing's great, because we can get the parents in the school district on the same side against another agency. That's a lawyer stream comes true. So that standard reasonably calculated for significant meaningful benefit. It's still the standard. You may have heard, we put a bunch of stuff on our website and shot newsletters out, and so did everybody else that does this. That in March of last year, the Supreme Court got its hands on a case to help define what appropriate means, and it was the first time in 35 years that they had gone to that issue of what's appropriate really mean. What they came up with is the standard that an appropriate IEP is one that, an IEP is appropriate if it's appropriate in light of the child's circumstances. It's a little circular. It's appropriate if it's appropriate in light of the kid's circumstances. So, it drills home that argument that we have to look at every kid individually, and we don't want to use cookie cutter notions of, you have to have an autism diagnosis to get ABA. If a kid with Down syndrome needs ABA, then we'll give them ABA. But I'm not sure that the decision gave us that much more in terms of understanding what appropriate means. It did give parents really good, strong rights to get information from the school district about why they think their programs are appropriate. But the parents who are already at the point of asking that question, they're going to get the answers with or without the Supreme Court. We want that benefit that we're looking for, the significant, meaningful benefit, to show up in all areas that are impacted by the kid's disability, all areas of functioning. So this list is not for every kid, but these are some areas that you can think about for your kid. Academics, academics, we're gonna think about social skills, emotional functioning, coping skills, behavioral functioning, physical stuff, OT, PT, that stuff, sensory, And really anything else that you can think of that might limit your kid's ability to be successful after graduation in employment, further education, or independent living, those are the areas that you want to worry about as parents, because they're the things that your kids are going to trip over as grown-ups, and they're the things that you're encouraged to bring to the IEP table to discuss during the process. And the only things that are never educational, and the argument sometimes is out there, like I suggested with the behavioral stuff, that school districts will say that behavioral issues outside of school aren't educational. It may not be in every case that they're educational needs. It could be resulting from home conditions, family issues. I have a case now where the parents are fighting constantly. They're in the middle of getting divorced, but the kid's behavior went through the roof, and I have to steer those parents away from trying to go too heavy after the school district, because they're going to fall on their faces if they do. The only two things that school districts are allowed to say no to, regardless of what the kid's individual circumstances are religious services, because of the First Amendment, right? Church and state stuff, and medical services, which are carved out by Congress in the IDEA, that special education and related services includes really anything you can think of, like I'm suggesting, that helps the kid in his areas of need or her areas of need resulting from the disability, except medical. Medical is defined by the Supreme Court as services that have to be provided under state law by an MD. So we're not really going to argue with the school district about that stuff anyway. If you want to go to the school nurse to try to get your kid an appendectomy, then you might want to re-examine this whole parenting thing and see if it's for you. And let's see, the last piece before we actually get into a little closer to what you all called me out for, this idea of program then placement. It's something that it's important. It's not always the way we do it, but the way that I learned it, and I don't know if it's the way you guys learned it, tell me if you got different ideas, but what we want to do is figure out what the kid needs before we decide where he's going to get it or where she's going to get it. So we're going to develop the program before we decide on the placement, and there's a simple reason for that. If we think this kid needs 4 sessions a week or 3 sessions a week of speech language therapy, but we put her in a school that the speech therapist only has 2 slots available each week on her calendar, then there's a really strong incentive there for the district to say that the kid only needs 2 sessions. So we want to decide how much does she need, and then figure out where we're going to get it before we start looking at actual placements, the individual classes or buildings that your kids are going to be in, because otherwise we'll end up intentionally or unintentionally writing the IEP to fit the placement instead of writing the IEP to fit the kid's needs, and then making sure that we give the kid an appropriate placement to receive those services. The reason I was kind of hedging on that is we're all placement centric, and we go into our meetings, if you're interested in out-district placement, then you've probably got one in mind, and you're going to go into the meeting asking for that, without getting hung up on the details of the program, and same, school districts may come in and know what placement is going to fit your kid, and they can want to go right to that question, and there's no harm in doing that if it's comfortable for you. I just want to suggest to you that if you're not sure that the placement is the right one for your kid, then it's useful to go through the IEP process and really work out the details of the kid's program, which we're going to talk about how to do that. And then you see whether or not the placement that is being proposed does or doesn't fit whatever it is that you figured out your kid needs before you got hung up on placement stuff. So the IEP team, the takeaway from that slide is the number 1 on the list to me is parents. The special education teacher of the child, regular education teacher of the child. Just a tip, that of the child language has been interpreted to mean that it has to be a teacher who actually has experience working with the kid in a classroom setting. So if that's not present in your meeting and you want to have somebody who actually knows your kid from the classroom present, then feel free to go for it. I'll also suggest to you, and it's not just because these nice people would beat the crap out of me in the parking lot when I walk out, but the procedural violations, if they don't have the right teacher at the meeting, for example, it's hard to win on that. I get parents that come in thinking they have great arguments, get great cases because they catch the district on procedural stuff like that, and sometimes it's enough, but usually we need something showing that there's a direct impact on the kid. So if they have the wrong teacher, you need the fact that they have the wrong teacher plus a little bit of evidence to show that somehow it had an effect on your kid, a negative effect on your kid, before it's worth it for you to go chasing after that. Why to include parents here? I'm not just kissing up to you now. This is actually written into the legislative history, the back and forth that took place on the floors of Congress when they adopted the IDEA, that these are the reasons that we want parents involved, because they're going to be the ones with the greatest knowledge of the kid, because it's your kid, and nobody's going to know your kid the way you do. So, when we're talking about a system that's designed to allow your child to make progress, figuring out how much progress your kid can make is an important task to undertake. And I get so many cases where parents think their kid's capable of more, and they know it because they see it. They see little blips, and I have this with I have a daughter with disabilities. I have a sister with real serious disabilities, which is why I do this stuff. And in both of them, I get those little messages sometimes that they can do more, they want to do more, but they're not being given what they need to do it, and that's something that parents are uniquely positioned to pick up on. So, to the extent you have that information, bring it, which is the second reason for you to be on the team, to provide information about what your kid's doing outside of school, which is still going to be 2/3 of their day, or 3/4, depending on how long. I can't do math. When am I doing fractions? And the parents are going to be the ones at the table, with no disrespect to anybody else, who are focused solely on the kids' needs and only the kids' needs, without having to think about any of the other factors that might get implicated when we're trying to teach a kid with disabilities. Yeah, yeah.
Is there a role for the principal in the IEP?
Sure. Yeah, this idea of the IEP team, I didn't put on the slide, but I maybe I did. Others. Yeah, others. Others means
there's
anybody.
Mandatory and then
Right.
and then
Permissive.
anyone else.
Yeah, yes, and the anyone
They're
else
in the anyone else.
can include
School nurse.
anybody, should include anybody who's got a stake in the process. So, parents can bring outside therapists, private evaluators, whoever, and school districts. There's nothing, that would stop a principal from being part of the meeting. You don't have to tell me because I don't want to put you on the spot, but I've run into the situation too many times where the building principal is like the #1 roadblock to getting a kid an appropriate program, because they seem to get taught in principal school that they're the captain of the ship, and
No.
Judea, we're not going to
I can
have
honestly say no.
Good. We're not in other districts. The principal will get all, for Shumwell, if the special ed people come in and tell him he has to do something or she has to do something differently because the kid's IEP requires it, and that back and forth is unpleasant for everybody. But I'm glad to hear it's not an issue here.
No.
So let's go real quick through what are the pieces of. Is this okay so far?
Mm-hmm.
Yes.
Is this like what you want to hear? I could tell Joe would say. Let me hold it. If I had more time, you're lucky. These are the pieces of the IEP that we're going to start with: the present levels of academic achievement and functional performance, or PLAF. I really missed PLEPS.
I did so.
That was so easy. We're going to have
Yeah.
a statement of measure. I'm sorry?
The PLAP. It was
Yeah.
easier to say too.
Yeah, PLAP and PLAF. Measurable annual goals, short-term objectives, a statement of special education, statement of related services, accommodations, and supplementary aids and services. There's other stuff that's required to be in IEPs, but this is stuff where I think parents can get some traction.
Could you define what a measurable goal is? What a good measurable goal versus a non-measurable goal?
I could define it for you. It's giving examples where in the easy areas I'll do it, but let me throw it out there. And I think this is in there, that, you know, for the goals and objectives, we also want the same thing for the present level statement. The information that's in there, we want to be specific, objective, observable, and measurable. So those are the four things that, you know, I've pulled out of different cases here and there that courts look for when they're judging whether or not the goals and objectives or the present level statement meets, you know, what Congress intended. Specific, you know, we want it to be, here's what we don't want to have: a situation where the goal, you know, halfway through the IEP term, so if it's an IEP that's in effect for a year, then 6 months into it, we want everybody to be able to sit down and agree on whether or not the kid is making progress with this IEP, and the goals and objectives are the most important way that we're going to measure whether or not that's true. And we can't do it if we have subjective terms in there, if we have opinions or you know, things that aren't specific, objective, observable, measurable. So an IEP that says that, you know, Johnny will behave appropriately doesn't get us anywhere, because we all know that appropriate is what we're going to shoot for, but, you know, what's the IEP telling us? So with behavior, you know, we can break it down into, you know, observable traits. You know, the behavioralists, the ABA people will tell you that all behavior is measurable, and, you know, they have their ways, and you guys have your ways of measuring behavior to figure out, you know, how many times does it occur during a particular period of time, or in a day, or under what circumstances does it show up, or when doesn't it show up? If it's a desired behavior we're looking for, like, you know, requesting something instead of, you know, just grabbing on somebody in the pool to try to get the message across. It's the examples, you know, like reading, I can give you.
You wouldn't say Susie will learn to read.
Right.
That's not doing it. She will learn, even, I would think, depending on the child, even if a specific goal is letter word or sound symbol relationship, might not be the whole alphabet. It can get as very specific as that. Maybe the child's only able, the measurable, specific, appropriate goal is 8 letters.
Right.
And then once you get there, you go, you know, it could be.
All right.
Yeah, that's a great example.
No, I'm saying learn to read. Well, okay, where do we go with that?
Well, right,
Are we
that
talking
would
like
be a
Tolstoy or?
What?
Are we talking
That's-
Tolstoy or Spot?
Yeah, so the more specific, the better it is to measure.
And sticking with Kim's example, Kim,
Yes.
okay. You know, if we're trying to get a kid who doesn't know the alphabet to be able to read, then Kim threw out, you know, that we might suggest that the kid learn, you know, 8 letters or the sounds that correspond with 8 letters or whatever, the way reading people would write that. When we're talking about whether or not the IEP is appropriate, this is the time for you guys to weigh in with your opinion, if you have it, that, wait a minute, you know, my kid can learn 18 letters instead of 8, or my kid can learn all the letters. And that gives us a really easy way to throw in an idea that when you're figuring out if the IEP is appropriate, you need to factor in your kid's potential, which is what I was suggesting before, that you know, parents are in a position to have some insight into the kid's potential that's going to be useful in developing the IEP. School district folks have insight also, and you know, it's through the IEP process that you're going to work out any disagreements.
Well,
But
so
that's a good measure, you know, 8 versus 18 or 10 or whatever it might be. And the right number is where you end up. Hopefully it's the right number.
So along those lines, this was actually brought up in a separate meeting I had attended regarding the IEP process, talking about, you know, when you do these goals, as parents, should we be looking at goals that are achievable or even maybe stretch goals? Like, are we challenging the schools to really, are we challenging them enough? Should we challenge them more? Should we challenge them less? Should we, you know, are we, stop shaking your head. I'm just kidding.
I was going to say, no, I already answered that one.
Well, I mean, I'm going
No, I'm not
to
shaking. Wasn't I shaking?
I'll tell you
Yeah,
the
it's all-
parent side answer.
Yeah.
You know, part of, I don't represent school districts. You know, that was a decision I made early on. There are some attorneys that do, And I think it's, you know, too much of a stretch, you know, from the point of view of trying to be like really, you know, kind of interested in moving the thing forward. So there are great attorneys that represent school districts that would give you a totally different answer, and you know, who's right? You know, the answer is somewhere in the middle. My answer would be that if you have reason to believe that your kid can achieve the stretch goal, and if it's a goal that we can really tie to those post-school outcomes of a success in employment, further education, independent living, then those are the ones that you can push. It doesn't mean they have to go all the way. That's where we get, you know, run into this, what the Supreme Court also told us, and it didn't change after the March decision, that you're only entitled to an appropriate IEP. You're not entitled to the best IEP. And you know, many school districts still provide services that are, you know, everybody around the table is trying to do the best for the kid. But you know, if you end up in court, then just because you can show that your kid may have been able to make more progress, it doesn't mean you automatically win, because you know, the district's required to allow the child to make reasonable progress, you know, significant, meaningful progress, not maximum progress.
Up to their potential.
But my suggestion to you would be, you know, if you've got that stretch goal in mind, push, and that's your job at the meeting.
And in terms of, I lost it. Sorry, that's what happens when you small children. I'll come back to it.
Okay, you want to work on that?
Yeah, I'll think about it.
So the information sources, these are just some suggestions of places that you look before the meeting, of what you might want to bring to the table. And you know, most of them are self-explanatory: evaluations, progress reports, work samples, teacher reports, parent reports, third-party provider reports. The last one, I'll spend a minute on that. A lot of you have your kids involved in outside activities that are disability related, either private therapies or social skills groups, or you know, just recreational activities for kids with disabilities. The people that are providing those services probably have some good insight into what your kid needs in terms of an appropriate IEP, and you're allowed to bring their input to the table, either by having them write up, you know, a little short summary of, you know, where they see the kid and what they think your kid's needs are, or actually have them at the meeting. That's under that others category. So if you want to bring them to the meeting, and if they're willing to come, then there's nothing to stop you. And sometimes they have really great information to share with the district about what's going on. And it also allows them to coordinate with the district so that, you know, what they're doing can mesh up with what's happening in school, to try to, you know, not confuse the kid, and hopefully, you know, build some, God, am I going to say business speak synergy?
Can I ask you a question about that?
Yeah.
What's the district's responsibility in receiving and acknowledging that third-party provider report?
The school district, I'm just looking, I can't believe this is hard. I'll answer that in a second.
Sure.
I am like really just super mad and embarrassed too that
What's on?
This is such a like rough draft of this thing that got printed out instead of the final version. And I have a sign up thing. If you want to leave your email, I'll make sure that anybody that puts their email there gets the actual like final version of this thing, because we do have it. It's not like I just got tired and stopped working.
I'm going to get the slides and I'll put them on the website after
Okay,
this.
cool. So I'll send it to you. Mm-hmm. And the district's obligation, when they get that information from outside providers, if we're talking about evaluation reports specifically, then they're required to consider it, you know, which is, you know, it's here's the again, the parent side view of, you know, what it means to consider it and be able to, you know, say that with a straight face to a judge that, yeah, we considered it. That, you know, they have to look at it. You know, they can't refuse to take it, which I hope it doesn't need saying, but there are districts where, you know, I get parents who tell me that the district wouldn't even take the evaluation because they didn't think it was needed, or they didn't trust who did it, or whatever. But they have to take it, they have to look at it. And if the evaluation includes recommendations, which hopefully it does, then, you know, I think that the school district has to be able to articulate a good faith reason if they're not going to accept the recommendations. You know, they can't just say, we don't have to do that. You know, that's not required for an appropriate IEP. It used to be easier for them to make that argument. The Supreme Court decision in March, I mentioned that, you know, it really ratcheted up school districts' obligations to provide information to parents. And this piece of that decision hasn't really caught on with judges yet, but, you know, give me a chance. The language that the Supreme Court used, you know, was essentially, we're going to give school districts, you know, their folks, the benefit of the doubt because they have all this expertise in the area of special education, but we can only do that, we, the Supreme Court, can only do that if they lay out their reasoning at the IEP meeting, why they think their IEP meets this standard that we, the Supreme Court, put out today. And moreover, at a due process hearing, they have to be able to show why, you know, they think their IEP matches what they defined an appropriate IEP as. And at the end of the day, I think that might kind of turn upside down the burden of proof, which it's not an issue in New Jersey. The burden of proof is on school districts because New Jersey passed a statute, but in, I don't know, just realizing as I'm saying it, it's in Pennsylvania, New York, the burden of proof is on parents usually in due process hearings. So they have to look at it, they have to think about it, and they have to be able to explain if they're not going to accept it. You know, I get parents who think that the district has to do whatever's in the evaluation, and that would be too, you know, harsh on districts. And I get districts, you know, who think that they don't have, like I said, you know, that they don't even have to look at it, which is, you know, dismissing the importance of private evaluations and independent evaluations. Other information, there's nothing written about, you know, if you get a status report, you know, progress report from a private speech person, there's nothing that I can think of that says, you know, exactly what they have to do, but I'd suggest that they still have to consider it, and that they can't just throw it out, and they don't have to accept it, but if they're not going to accept it, then they should be able to articulate a good faith reason why they don't have it. It's not really an answer, is it?
Oh, it is. I think, because some of the feedback that I get from folks is they'll get, well, we don't offer that service as part of the IEP. To me, that doesn't sound like a good faith reason, especially when you back in free and appropriate education.
Right. Yeah, the we don't do that here answer, and it gets shot down left and right by courts. So if that's the reason, hippotherapy is my favorite example, horseback therapy, you know, there's all this evidence that works for kids. And I'm going to look for the examples that, you know, really like strain the system.
Oh, right,
you know?
right.
Like I'm not going to go with the easy stuff like, you know, speech therapy. We all know if your kid needs speech therapy, your kid's going to get speech therapy. Yeah, but what if you have like really good information showing that your kid needs horseback riding therapy? Mm-hmm. You know, I have an even worse example, but out of respect for Kim and Mark, I'm not going to.
No, go ahead. It's fine.
No, because it's just going to complicate everything. So stick with the horseback riding therapy. You know, like everybody wants the district to pay for horseback riding lessons for the kids. Yeah. So, you know, if we made that, you know, the rule that this is something that you can get here in Bayonne, then before you know it, they can't afford to buy books for, you know, any state. So, you know, I get it that lines need to be drawn, but the argument that I put out there as the parent side guy is that if you've got credible information showing that the kid would really benefit from this and be able to make progress in an area that relates to that employment, further education, independent living goal, and the district doesn't have some other way to allow that kid to make significant, meaningful progress in that area, then, you know, they should be helping getting the riding boots on. What you're going to find, you know, when you start asking for it, though, is that, you know, one of the benefits of horsey therapy, you know, for kids with behavioral issues, for example, is that, you know, helps them behaviorally. The district may have other ways to address the kids' behavioral needs, and if what they're doing is appropriate, you know, meets that level of being, you know, reasonably calculated to confer significant and meaningful benefit in all areas that the students need, then you're not going to get it. And before you get your feet too far off the ground with this, remember you're in New Jersey. You know, regardless of what you think of what's going on here, there's a huge problem that the state has caused, and, you know, I'm trying to be, you know, non-adversarial with the folks here because they got these jobs probably because they care about kids and they want to do the right thing. The state has really underfunded special education, and the feds have really underfunded it. When the federal law was passed, Congress said we were going to kick in 40% of the cost of special education programs for states, and they've never gone above 13%. So you've got the feds not pulling their share, and then the state not pulling their share. So if you're going to be mad at anybody, you know, I go after the state. I really don't like those folks. Not individually, but collectively. So.
Can we sue them?
What's that?
Can we sue them?
That can't be right.
Wait, what did you say?
Can we sue them?
Yeah.
At the state?
The state.
No,
No?
you can. Like, I'd love it if you do, but you know, you end up with legal fees and you know, several hundreds of thousands of dollars because the Attorney General's office knows how to run your fees up. So it's really a mess.
Mr.
Yes,
Ryan?
we have discussed that.
Are we still, to your knowledge, Bayonne being the most underfunded?
To the best of my knowledge, we're in the top 5.
Yeah, okay,
easily,
what-
and that has been discussed about taking them, your argument about how expensive that would be. I can't get into it because that's part of the thing, but let's just say that's a football that's being kicked around the room very aggressively.
Mr. Ryan's a board member. I'm
Yeah,
sorry,
I
Mr.
learned that earlier, and I'm very glad to have him present also. And you know, I'll just say, you know, that issue of going after the state. I have wanted to see parents get together and do it, to sort of pull their weight. And we had this great opportunity with a couple of cases in South Jersey that parents and districts were on the same side, but we couldn't get the districts to cooperate with us, and the districts probably would say the same thing, that they couldn't get us to cooperate with them. So we didn't do it effectively, but if parents and districts got together, they could, there's so many areas that the state is just miserably out compliant. Just things that are completely illegal, completely indefensible, but it also takes a great effort to get to them. So if you guys want to do it, I'm there for you.
From the Powerball.
So let's see. Okay. This thing's missing so much. Okay.
I did think of my question, if that'll help you.
Someone is here though. Yeah, go for it.
Just going back to the measurable goals, one of the things that I was curious about is when you're in the IEP meeting, I wasn't able to get an idea of what the general education curriculum would have been for my daughter, for any, in the course of that. Is that a typical thing to ask for? Is it something that could be generated? For example, if my daughter's going into kindergarten and in the general education curriculum says she needs to, by the end of kindergarten have all of her sight words, 120 sight words and all the ABCs, and she has this list of, I'm sure teachers have a list of, the curricula for
It's
the.
in every building.
Right.
It is available by the general ed.
Okay, because that was something that I
reach out to your
personally
principal
had
would
trouble
be
with.
quickest,
But, okay.
probably.
So yeah, is that a reasonable thing to ask for in an IEP process, so that when you're setting your goals and your stretch goals, maybe we can get her to the place where the rest of the class is, even if it. Anyway,
Yeah,
that was my sort of question.
Yeah, I think you can ask for it. It's also, the district has to follow the core curriculum that the state lays out, which I personally find to be kind of useless in terms of figuring out goals and objectives for an individual kid, but it's still a place to look, for the direction that you want to focus your efforts. And what the law requires is that the IEP be written to maximize the kids' exposure to the general education curriculum. So in areas that the kids can participate in the general ed curriculum, the kids should be doing that. We shouldn't be watering programs or expectations because this kid has an IEP. But then there are plenty of kids that it's not realistic to expect them to be able to get by on the general ed curriculum, which is the definition of special education. So.
See, because we're mandated to link, right? So we have to show, and this is a problem, and we understand we try to explain to the parent, we have to put the Common Core and link in the subject area in the goals and objectives.
Right.
Is it necessary?
Well,
Okay, listen, is it really necessarily meaningful to that child? No. But it has to be in there, and it's very, very modified. It's just like taking the DLM, when some of these parents will, their children, see that test?
Yeah, it's a mess.
It's a mess. But they're like, figure out a way. The things that they want the children to do, it's a mess. But anyway, and maybe it will be better since APA is gone and DLM is totally taken over. So we tell parents, we realize that this is not realistic, but by law, we have to have a Common Core literacy, something, and math. And then kind of move on to individual
Right.
kind of goals. A lot of parents were like, yeah, I don't want it, it's ridiculous, I want it out. I'm like, you know, it's kind of got to be in there, kind of.
Yeah, that's,
You know, we all agree it's ridiculous for this,
Yeah.
but we have to, you know, so that's what we're up, but, and the fight will be, but yeah, I want it out.
right, and it's more common that parents complain that there's too much effort made to align the kids with the general ed curriculum
Yeah.
and not enough individualization. And you know, the state has school districts chasing their tails because they do have to put the general ed, you know, the Common Core standards in, and you know, then try to fit the goals and objectives into that framework, which might not work for every kid and is the opposite of individualization. But
Right.
you know, it's
How long have they been doing that, Kim?
forever.
Oh, yeah.
That's
I
not
don't
the
remember
deal.
looking on my
The
page.
standards change, but.
Well, yeah, that's another thing.
Right.
Leave them for a couple of years at least. So they're changing the standards all the time. Science standards are, you know, next generation science now. So we'll have to change the standards in our program. So it's a lot, it is a lot, and it is chasing tail, but.
So I just flipped to the page, present levels of performance, because there's stuff missing. You know, I know it all, so I'm going to tell all of you that it's not in here. And you know, I'll send it. What's your name?
Sarah.
I'll send you know the final thing to Sarah, and she'll get it to you. But that present levels of performance, and the next page about goals and objectives. You know, this is like if you're going to pay attention, pay attention. This is the stuff that you know I have actual hands-on experience that if we get this part right, we don't end up in due process hearings. It's not always possible to get it right, and you need you know everybody at the table to be willing to participate in it. But I don't find school districts really push back when you're talking about like goals and objectives. You know, and if you want to ratchet the goal up for your kid, you know, it's not as likely that you're going to get a fight about that. It's all depending on your kid's individual needs. But you know, these are areas that you know you can really make your life easier. And there's a method to this whole process, you know, to the whole IEP, and this is the core of it. The present level section, we're going to be explaining where is this kid as of the date that the IEP is written, and we're going to break it down into those you know, 4 characteristics that I mentioned before: specific, observable, objective, measurable. You know, so we're going to report information as factually as we can, as you know, free of opinions and subjective information as we can. So we're not going to say that you know Billy has a problem behaving appropriately. We're going to report the actual behavior that we're observing, or you know misbehavior if that's the case, and you know give it as much detail as we're able to muster. And we're going to do that in all of the areas that we want addressed by the IEP. So those areas from the earlier slide, you know, about academic and social and emotional, behavioral and physical and sensory and whatever else was on there, you know, that you can use you know, to help figure out what the right areas are for you to push for your kids. And you know, it should be a detailed statement, and it usually is. You know, it's not something that districts often skimp on. It's just making sure that it matches those criteria: specific, observable, measurable, objective, which I did out of order, so I hope I didn't confuse you. The reason that we want to make sure that these statements are complete and accurate and specific and all that is we're now going to use that as the starting point, and then we're going to use the goals and objectives to figure out what the end point is and what's the goal. So when we set the goals and objectives, what we're saying is with an appropriate IEP, with appropriate services, for goals, how much progress do we expect this kid to make over a period of 12 months, which is a year, obviously, but you know, I've had school districts argue that the goals in IEP, if they do the IEP in March, it only has to go till the beginning of the next school year, which is July 1st. It's no, the law is clear. The United States Department of Education told us that a year means 12 months. So the 12 months that are encompassed by this IEP, where do we want the kid to be at the end of the 12 months? And then this is an area that New Jersey is fortunately non-compliant on the right side, that under the federal law they only have to do objectives for kids who have intellectual disabilities, formerly known as MR. The state practice is that everybody gets objectives, and that we do goals, we still do objectives, and that's important to me because the objectives are the way that you guys get filled in as the year is going on, whether your kid's on target to make that goal, because obviously you don't want to have to wait a whole year to figure out if this is IEP's working. So if you get into the first progress reporting period, if you have quarterly progress reports, and you're getting the feedback, because the goals have been written and the objectives have been written specifically, observably, objectively, and measurably. I don't know how I got on that Lee thing. Then you're going to be able to compare it to where the kid was at the beginning of the period, which is in that present level statement, and figure out whether or not your kid did or didn't meet those criteria that you guys came up with around the IEP table that you expected him to. And if he didn't or she didn't, then that's a red flag that we might need to go back and readjust things, either by changing the services so that the kid's able to make the progress that we all think he or she's capable of, or sometimes maybe we set the expectation too high and we need to lower the benchmark, the objective. But this is something that Jason asked that question. How do you actually do it? It's tough at the table. To like reading, you can do. You can say that your kid will be able to decode at this your kid's at level X and you're going to move your kid to level Y. It can be measured, it can be reported, and you're not going to argue about with the district. But when you get into things like social skills and being able to interact appropriately with somebody in a conversation, that gets kind of more difficult to measure. But the folks that I've worked with that are really tuned into this stuff tell me that, like I said, everything that you do is behavior, and every behavior is measurable. So we just have to make sure we're looking at the right thing. And the example I asked, remember Ann Holmes from Eden?
Yes, I do. She's worked here for several years.
Yeah, and she's still. Do you still have her?
She's her own now.
Right. Yeah.
Yeah.
Yeah. I mean, Ann's
no,
great.
she's cut us loose.
Okay.
But we used her for 5 years.
Yeah, and she's great.
She's great.
And I asked her, in social skills, like, give me an example of like a measurable, specific, observable, objective, and measurable goal for social skills. And she came up with something along the lines of, when approaching a group of known peers, Billy will introduce himself into the conversation by saying, "Excuse me," 3 out of 5 times or something like that. Like that's a way that you can even take these really difficult things to measure and measure them. With emotional stuff, I don't have any examples for, a kid will not always look at the negative, things in his life, and that he'll have like a more positive outlook. Give me an objective for that. But
what about academics that's, you can see it, it's observable that they're able to do it, but they do it at home, but they're not observed at school doing it. They're not comfortable enough or whatever is happening, they do it for homework. It goes in, but they won't do it in school.
That's such a weird question. I mean, it's a good question. That's weird. Because it's always the opposite, right? That the district says the kid can do something, and the parent says he can't do it at home.
Usually.
I think count your blessings, right? Like, I mean, in terms of what's in the IEP, I think everybody has to reflect that. And, maybe it's not the actual academic levels that are the issue there, but the fact that the kid's not able to perform in different environments, which is just another generalization, just from home to school instead of school to home. And And so it's important, to bring it to the table, and it's something that would have to be folded into defining appropriate goals. And I guess the concern is if the district underestimates what the kid can actually do, then he'll end up spending the day learning something he already knows how to do, and then he'll get frustrated and stab the kid next to him with a pencil, and that's how it always turns out. Hopefully not. But yeah, I think drilling down on the more, I think in that situation, I'd want to figure out what it is that's happening that prevents the kid from applying those skills in the school. And hopefully it's something that can be remedied. So,
Well, to that point, in terms of remediation for things like this, I know from having gone to these meetings that I can ask for an IEP meeting anytime. And if you don't know that, you do now. Anytime you want, you can ask for an IEP meeting. What other types of remediations are available to you as a parent when you see something like this, for example?
For that kind of situation, I'm trying to figure out, I'm saying, get some information on what's causing it, but I think, do you think it's an emotional thing, or is it behavioral? The kid just
maybe behavior. I don't know.
refuses
I mean,
to
I know
perform?
that's specific. I just wondered if there was something observable that it is a weird question. That's but
No, it's not. I went through it.
you did.
My daughter quickly was told that she was not doing something, and we were doing it at home. And fortunately, when Claxton was the teacher, during the fall, we went into the classroom and I demonstrated it. Long story short, there were several aides who were following the procedure correctly. So the kid was becoming confused. At home, she knew what to expect. I was breezing through stuff like these things to slice bread.
Yeah.
And in the schools, like, no, we can't do anything. It was about reading. It was about picture words and sights. And they were just not doing. There was 3 separate procedures on 4 or 5 different aids. How could the kid get it right?
When you put it that way,
It's a 20-year-old story, so I don't have to walk down, but that's what was happening.
Right, but maybe it's not as weird a question as I thought, because I guess that is an issue that comes up not infrequently, that parents complain that the district is having the kid work on stuff that the kid already knows, but for some reason the district doesn't factor that in, maybe because they don't have the evidence that the kid knows this stuff. So the easiest thing is to show the work samples or videotape your kid if it's a observable skill or whatever, so that the district can understand that it's not the actual underlying skill that's the issue, it's the transfer from school.
Alicia, I believe that's how you worked out the coin counting, is it not?
Yeah.
Yeah. The school didn't realize he could do coins, and Alicia's like, no, he can do coins. So we're like, okay. So then she sent in it done. We had worksheets reduplicated because we didn't want it to be rote, and we mixed it, and he could do coins any which way you presented it to him.
I didn't mean for it to be so specific. I just saw observable, and I'm trying to figure out with an IEP how to bring it in.
My first thing was to video it at home. Although that's the home part. I mean, that's just supporting what the parent is saying can be done at home, but it's still, you still have to get to why it's not happening in school.
Right. Yeah, it's an interesting situation, but
Because it's the reverse.
As bizarre as I was initially.
It's reverse.
So thank you for bringing that up. So what's been designed for you in the IEP is this built-in accountability system to make sure not only that your kid is learning the right things, which is important in terms of when you're writing the goals and objectives, you want to target the areas that are going to directly impact your kid's success after graduation, unlike a broken record, employment, further education, independent living. But it's also a really important and useful way to bring you guys into it, because if they're written right, the goals and objectives in the present level statement, then it doesn't matter if you never graduate high school or if you have a PhD in special education, you're going to be brought into the process because these are things that you'll be able to see. By definition, right? If it's observable, then it's something that you can ask your kid to do. If the district is giving you a progress report that says that your kid is able to tie his shoes, you can say, Billy, tie your shoes, and either he does it or he doesn't, and there shouldn't be an argument about it. And this is how you get rid of the lawyers in the process, because when these things are written right, the feedback is given not just to you, but to the district, and if the district has to write progress reports that say that the kid is not meeting any of the expectations in the IEP, as of the end of the reporting period, whatever it is, then they're going to know that it's not, not only are they're going to want to do the right thing, right? But they're also going to know that if they don't, that they're at risk that you're going to call them on it, and that would be an easy argument to make to a judge that the district itself set these goals in the IEP or these objectives. The kid isn't meeting them, so we need to do something different. And no district is going to go to a hearing with you on that. So if you want to get me out of the process, can just write really good IEPs, which I bet you do.
I'm not always,
Okay.
but
Well, that's
I'm honest. We have our issues.
Yeah. I don't know what, but and you have to say.
No,
But-
I mean, listen, I'm honest, that's one thing I am. We have compliance issues, we do.
Do we
We also
want to say
have
IEP?
a very, and not that this is any excuse, but we have a very large population,
Right.
and we are very low in the amount of team members we have. We're juggling, and that doesn't make it right,
Yeah.
but
It's unfortunate, they're
But we certainly, and as issues arise, we correct, or try to correct, or do the best we can to correct, and if we can't, then, yeah, you have every right to file. That's up. Yeah. I shouldn't say that, but
no, you
that's,
seem pretty cool, so
Well,
I don't expect to have a lot to do in Bayonne. If anybody needs me, they can call, but if you do this stuff that I'm telling you, like write the IEP right, don't tell my partners I'm telling you this, but before you spend money on me, go get like a really good private evaluation of your kid. If you want the district to pay for it, there's a process, there's a mechanism for doing that, but you might end up spending 6 months or a year just arguing with the district about, or negotiating, with the district about whether they're going to provide that evaluation or not. If you can do it, just dig deep, get a really good evaluation by whoever is the best of whatever your kid has. So if your kid has autism, they're in wonderland, because there's so many autism experts who are internationally known, and they really bring great information to the table. And the smart ones know what's realistic and what's not. So the district doesn't end up with an evaluation, and you don't end up with an evaluation full of recommendations that just can't be implemented or aren't going to fly in a real world setting, which unfortunately experts do. But if you find somebody that knows not just what they do, but also the system, which you can figure out just through talking to them, and get a really good evaluation, that's going to get you a lot further in developing the appropriate services for your kid. And then you can use that person to help write the goals and objectives if it's needed. And as I said, it's not guaranteed, but districts don't fight about that, because it's not an area that either side really can go to court and really fight out. But it's also just not something that I don't know why they don't fight, but they don't. So if you can develop that really good IEP, then as I said, it becomes the mechanism that keeps you tuned into the process and into your kid's progress, so that you know whether it's working, and the district will know also, and you'll have that evidence of progress reports. Progress reports, by the way, the ones that just have, N, not progressing, introduced, progressing, and mastered.
Well, yeah, emergent. See, we have progress reports that are directly linked to the goals and objectives. So the teacher can print those quarterly that go out with the report card, the old report card. Progress reports, they call them the same. So the children will get a district, and then they'll get the insert of the specific Goals and objectives, so I always get confused, like, what's on the report card? MEE, and then we're emergent, progressing, not introduced.
Right.
So there's two here.
Yeah, so the more detail you can get into the progress reports, if the objectives are really broken down into those specific objective, observable, measurable characteristics, then that type of system with the N and not introduced and emergent, whatever you're talking about,
Yeah.
and that can work. Another thing to focus your energy on, the goals and objectives, and it just, when you said that the goals and objectives, I'm sorry, the progress reports are tied to goals and objectives.
The one is, the department one is, and then
Right.
all the children receive yeah.
The goals and objectives should also be written in the same terms that the present levels statement is, and it's something you can ask for. It's not automatic that the district has to do that, but again, this isn't something that they often fight back on. And I'm really, I gotta figure out why that is. But if it's written in different terms, then you're not going to be able to compare the before and the after to figure out whether or not the progress is there. I'm not saying don't believe the progress reports, but you're entitled to verify what's in the progress reports. And like I said, if this is written right and it's observable stuff that you can ask your kid to do, or you can observe whether or not your kid's actually doing it, then you're given the information you need to be able to make changes in the IEP. If your kid's not making that progress, just having the same units of measurement in the present level section makes it a lot easier to compare the goals and objectives and the progress towards the goals and objectives with where the kid is on the date that the IEP is written.
Are there any requirements on the number of reports or progress reports that have to be provided? Like, do they have to have a semester, or is it just once a year?
No less frequently than information is given to parents and non-disabled kids,
Yeah.
which is usually quarterly.
Yeah. So in the reporting section of the IEP, it'll say progress reports, and then times, depending on the child, either 3 or 4. And then what we do is, if the parent wants additional progress reports, and that goes it, it says annual, re-eval every 3 years, annually, progress reports, whatever the district is per grade, and then there's another statement.
For supplemental,
As
whatever,
as requested,
Okay.
or as needed.
Mine's in pre-K, so it's all messed up. It doesn't
so,
match
yeah,
anything
so-
else.
There are plenty of times that parents get weekly
Yeah.
updates, and there are plenty of times where it's appropriate that the teacher give a daily update. Usually that's done in a communication book.
Yeah.
But the parent get daily feedback on how the kid's doing, because that's going to affect what the parent does at home. And that's you guys working
Yeah, you
together.
could fold that into the IEP, correct? So you could fold that daily request into the IEP.
Yeah.
Yeah.
Yeah. And that those schedules that Kim just recited are accurate, that reevaluations only have to be done every 3 years. And then when you get to the 3-year mark, the team's allowed to say, we don't need a new evaluation to figure out the two things. In evaluations, you're looking at whether the kid still has a disability and whether the kid still needs special education. And if you all know that, then you can agree that you don't have to do a reevaluation. But if you want, as parents, to have a reevaluation, they got to do it. But sometimes it doesn't make sense to wait 3 years. If the kid has a medication change 6 months into, after the last evaluation, and we think it's going to impact, how the kid performs on a reevaluation, that might make sense to do a reevaluation at that point to get the information about how the kid's doing. What the federal law says is that you're not entitled, they have to do a reevaluation whenever you ask for one, except they don't have to do more than one in a 12-month period. So, if it's appropriate, usually they will do it within that 12-month period, but as parents, you don't get that right to insist on it until years pass since the last evaluation. And same with IEPs, that you don't have to wait a year, even though they're developed, reviewed, revised on an annual basis. If you get 3 months into the IEP and there's whatever change in circumstances, either you're getting feedback that your kid's not progressing towards the goals and objectives, or there's a medication change, or parents get divorced or get back together, or one of them dies, or let's not do that. Then it might make sense, and it usually will make sense, to go back to the IEP table to factor in that new information and figure out how it's going to affect what we do for the kids. So those are maximum time limits that school districts have to do things no less frequently than that, but they have to do it more frequently if it's appropriate to do it more frequently, which is that term again, appropriate. But under those circumstances, with those kinds of changes, then they probably wouldn't fight you, and they'd have a hard time fighting you if they wanted to.
I just want to interject really quick for the sake of those here and who may see this in the future, that you can absolutely always ask, right, for any kind of progress report. I have a deal right now with with my daughter's OT and my daughter's speech, and they each at the end of the week give me a little, this is what she did, and this is her progress, and this is what we're working on. And I just asked for it. It's not in the IEP. They don't have to give it to me, but most of them are willing, and if you just ask nicely, they'll do it, so keep that in mind.
So is this the way all your meetings go? Like one side of the room does all the talking and the rest of you just fall asleep?
We could shuffle chairs really quick.
Well,
Sometimes we
we're
sit
not
there.
sitting in the right spots.
No, normally we sit there.
We're all
mixed up.
different, so we all happen to be in different spots.
So
There's just the
left
noisy
side of the room,
section.
So far so good? Or are we still on track with stuff that might be useful at some point? So goals and at present levels and goals and objectives thing. I used to have this great psychologist who hired himself out to help parents write IEPs. And there are plenty of advocates out there that'll help you write an IEP, but a lot of times, they put this stuff in that it just doesn't work, and it's not realistic. And this guy was so good at coming up with really good goals and objectives. Districts never disagreed with him because they were always reasonable and stated in ways that just weren't offensive or difficult. And he stopped, and I don't have anybody now, but ideally, like I said, if you're able to get one of those highfalutin experts to evaluate your kid, it's eye-opening if you've never seen a really good independent evaluation. Districts do very good evaluations sometimes, and I'm sure they're always wonderful here. No, you're going to tell me not always, but
Well, I would think they are, but I'm sure
Okay.
other people disagree.
yeah,
But
but as much as we get good information from districts, when you get a report that's 60 pages long about your kid, and that just goes into this minute detail about how he's functioning, and parents are so often just say, thank God, it's finally somebody really understands my kid. And then those people, if you get the right one, help bridge the gap between you and the district to help the district understand in educational terms what it is that you want to focus on in parenting terms. And the key is that you want somebody that does it in a way that isn't going to piss them off, and it's going to help them write a better IEP. If you need to piss them off, I guess do it, because that's what I'm supposed to tell you. But usually you're going to get more flies with. Do we want flies? If you want flies, you can get more with. Why do we want
why?
flies?
With honey?
Yeah.
Bees with honey?
So maybe vinegar's better. But anyway, let's see what I'm gonna
Oh,
have
if you want
go
to catch
off
the
script.
flies, you want to catch them to get rid of them.
Okay.
Yeah.
There you go. Thank you, Sarah. The pieces they're missing from here are probably the pieces missing from here are really important. One of the things missing is special education, which is kind of ironic because I got this complaint that it's not Bayonne's fault, it's not any school district, but it's New Jersey, the state again. They don't include special education in IEPs, which is bizarre, but I look at IEPs day in, day out, and I'm always looking, because in Pennsylvania in particular, most of my other stuff outside of New Jersey is Pennsylvania, and there's a section of the IEP. First of all, special education is defined as instruction that's specially designed to meet the unique needs it's a student resulting from a disability. So specially designed instruction is the definition of special education, which means that we're going to modify the curriculum, or we're going to modify the sequence or the materials, but we're going to make modifications to what we do for the non-disabled kids to allow the kids with disabilities to benefit from the instruction and to make progress that's meaningful and significant and all that. And in Pennsylvania, there's 5, 10, 15 pages in every IEP of specially designed instruction, very specific instructional techniques and strategies that are going to be used that spell out what is going to be done in the classroom. In New Jersey, in the section of the IEP where it's supposed to be, which is under special education determinations, we stick placements. That's where we say that the kid's going to be self-contained or resource center or separate setting, a private setting or whatever, and we just leave out the special education. And I've had a ton of fun with this, unfortunately, because it shouldn't have to come to this, but when we have hearings and these nice teachers, special ed teachers that just get beaten up in due process hearings, which suck, but they're the ones that know the most about the kids, so they're the ones that you want to get the information from. And you ask them, or the school psychologist, who's supposed to be very well informed about what's going on in special education. You ask them, where's the special education in the IEP? Invariably, anything they point to in the New Jersey IEP is required by some other section of the law. The law tells you what sections have to be in the IEP. So if you point to the placement determination, there's a requirement that the IEP have a placement determination. So if that's already required by the law, then what do we do with this requirement that the IEP state the specially designed instruction, the SDI, for the kid? And it's not something that you should spend a lot of time thinking about, but it is really revealing that we get away with IEPs here that don't have special education. And an area, did any of your kids have like dyslexia, specific learning disability in reading?
We do.
This comes up a lot with Orton-Gillingham type programs that districts in New Jersey believe that they don't have to include the specific methodology in the IEP, and I understand how they believe that, and their attorneys would chase me out of the room right now, as Kim and Mark probably want to do right now. But
they won't say the word dyslexia.
And that's
it's like a curse.
right. And that's like a throwback to before 2004. There were a bunch of cases that talked about districts don't have to include methodology in the IEP because methodology decisions are left to school districts. But there's a requirement in 2004 that the specially designed instruction and related services that are in the IEP use techniques that are proven effective by peer-reviewed research to the extent such research is available. So if there's research showing that a particular methodology works for a given population, then the district should include that, unless it doesn't have to use, it's not like you go and count studies and they have to use the one that has the most studies backing it, but this shakes out a lot with autism that, ABA, nobody argues anymore that kids need ABA, but it used to be that districts would not readily agree to provide kids with applied behavioral analysis programs, and kids with dyslexia, research shows that they can benefit from Orton-Gillingham or other, whatever it is, sequential and intensive sequential, I'm not going to get it, but the definition of what makes a program fall under that rubric of Orton-Gillingham. So if you're aware of particular strategies that work with the type of disability your kid has, then you can bring it up at the meeting.
I will say that my daughter, who has dyslexia, is very blessed to have one of the two, and there is only two in this district, who are certified in Orton-Gillingham.
Good.
And she is blessed to have one of those two teachers that teaches her. And she was very blessed because she was bounced from 5 schools before she finally found a permanent home. And it took a lot to get her there. And it took a lot, but she was blessed to have that teacher.
Seems the left side's got something to say.
Yeah.
That's right. You got, what I like, what I, love about that is that, things worked out, excuse me, and then you're, willing to say thanks, which, is great. And the other thing I like about it is, you just say to your kid, that they won't put in the IEP the word dyslexia, I think?
No, they say she has a processing disorder that affects reading and writing, but won't say the word. Won't say the word.
Okay.
Yeah.
Right. And
even though we went to the neurologist supplied by the school district that said she has dyslexia, but would not say it in the report.
Yeah, I'm not sure.
Wouldn't
But
say.
at the end of the day, it sounds like she's getting what she needs.
Absolutely,
And that,
she is.
kind of
She
shows
is.
that IEPs are maybe a safety net, that there are a zillion inappropriate IEPs all through the state, but most of the kids that have inappropriate IEPs are still getting good services because they're,
Yes, Allison is
given
getting what Allison needs.
what they need. This stuff is good to be able to fall back on if you don't think your kid's getting what he or she needs, or if you're trying to figure out what they need, then this can be a useful framework for it. But I certainly wouldn't look a gift horse in the mouth if the district's doing the right thing for your kid. As I said before, if they don't do the paperwork right, the procedural stuff, but you can't show that it directly impacts your kid's learning experience, then you're probably going to have a hard time convincing a judge that you're entitled to some relief. So IEPs have to include the specially designed instruction, which we just don't get in New Jersey. And again, if you want to change that, it's not Bayonne that's the problem. It's the state and the form IEP that they put out and the lack of guidance that they provide about how they should be giving kids what the law requires them to. Another thing that is a part and parcel of this is related services. The definition of related services are services that allow a child to benefit from the special education that's provided. The list that everybody uses, PT, OT, speech, transportation. Transportation is the easiest to see, right? If the kid can't get to school, then he's not going to benefit from the services that are provided. Nursing services, there's
Yes,
the two cases,
We do.
twice. What's it?
we have it here.
Right,
For-
and I'm glad
requires
to
it.
hear that. The Supreme Court had two times they had to deal with this case. The kid with a tracheotomy needed a nurse to suction the trach,
Yeah.
and the evidence was pretty clear. If the kid's trach isn't suctioned, then he would die. And the parent said, "District, you have to provide the nurse because if my kid's dead, he won't be able to learn anything." And the school district said, "No, we don't have to do that because it's medical." And two times that had to go to the Supreme Court, and the Supreme Court said, "No, unless it's an MD that has to do it, then it's not medical, and it's not excluded as a medical service." So it's a related services because allowing the child not to die in the classroom seems to be important to letting them learn.
Yeah, that'd be
So
great.
if any of your kids are at risk of dying in the classroom, that's something you can bring up with them. Yeah, sorry.
Don't die.
Yeah, but I'm making light of it, but it's obviously very serious for the kids. But the list of related services includes other things that may be useful. One of them that I think is pretty cool and that districts are usually on board with is parent training, giving you information to help you figure out how you can help your kid in terms of meeting his or her disability related needs, because to the extent that you're tuned into that stuff, you're going to be able to do a better job. And if you can mesh it up with what the school district's doing and let them make you a part of the team, then they're going to like you, first of all, and you're going to look great for a judge. If you're asking the district to help you help your kid, if you end up in front of a judge, the judge is going to give you a gold star, and they're not going to get one. But the good districts like Bayonne, they're going to give you the parent training. So that's something you can ask for. There are others there's a list of examples in the code, which the final version of this thing that you get has the quote from the code of the examples of related services. Like one of them is orientation and mobility services, which is for kids with either visual impairments or some other disability that prevents them from being able to get around without bumping into stuff. recreation and leisure services. Now it's just recreation services. I like that for kids with autism, or not I like it, but the experts that we've worked with suggest that's an area that you can look at your kid. How many of you have kids on the spectrum? Autism's just taken over this whole thing, which says something in itself. But the experts have suggested to me that to the extent your kid, when you take the pressure off for them to perform, if they just revert to very low level of functioning, like they just stare or they stim or engage in inappropriate behaviors or whatever, but they're not doing something constructive with most of their time or all of their time, then that might be a kid that needs to be given some specific instruction in how to use time off. And for kids with severe autism, I'm not sure it's going to have as much of an impact as kids who are able to receive that kind of instruction and sort of incorporate into their daily routines more. But I thought it was a pretty cool idea that non-disabled kids, when they have free time, they're still learning, they're still doing stuff that gives them greater skills, whether they're playing with friends outside or doing other stuff where there's social interaction, or they're reading something, or even if they're just watching TV. There's a difference between really engaging with whatever's on the screen and just letting it pass the time. And I know that from my own life.
Well, to that extent, just to rewind what you said before, I mean, when there are, you mentioned how schools kind of like to think about the school day and then they're done, and it's that window of their sort of responsibility. But what about school-sponsored recreation and allowing, whether it's somebody who, let's say there's a school soccer team, and your child is able to physically function, but requires maybe an aide to go with them to help understand the nuance of the team in those aspects. Is that something that
yes, we have to do it. We do it.
I love it. Yeah.
You have to do it. You do it, but only when
we have to do it
when it's demanded, or
well,
do you do it as a part of
if
part,
a parent
course?
says my guy would like to be on the chess team, but really truly can't be in the building yes, we have always provided aides to do after school activities. As they get older, certainly the prom. We have aides that go to the prom every year, with the kids, because they should go. So yes, if it's something a child wants to do, they are also, if they take the bus to and from school, they're entitled to the transportation as well.
Okay,
after the activity is over. A lot of times parents choose to pick up because it's 5 o'clock.
And when looking at extracurricular stuff, there's two ways to look at it. One is this something that can help the kid advance towards the goals and objectives in the IEP? And if it is, it might be necessary that the district include that in the IEP. More often, you're going to approach it from an equal access point of view, that can the kid participate in this and receive benefit from it like non-disabled kids or equivalent to non-disabled kids? And if the answer is yes, if accommodations are made or services are provided to allow the child to access, then the district needs to provide those services or accommodations. And so more often it's going to be like an equal access thing, which isn't necessarily part of the IEP. If the district is giving the access, but they won't put it in the IEP, I get that periodically, and it's usually not worth fighting about because there's nothing that says they have to put, those accommodations come under Section 504, which you might have heard of, and the Americans with Disabilities Act, and don't directly translate to an IEP. But yeah, that's, and we had there was a district that had an after school, like a latchkey program for kids without disabilities, where they had teachers who just wandered around the cafeteria. The kids were in the cafeteria, and the teacher wandered around. A couple teachers would wander around the cafeteria and help kids out with homework. They would provide loosely structured games and activities for the kids. You know, it was not an intensive learning experience, but there was some support being provided to help the non-disabled kids develop skills. And you know, we caught that tiger by a toe, and were able to show a judge that our kid with severe autism was entitled to participate in that program, but he couldn't do it there because the cafeteria is too big and too noisy, and he'd never be able to handle it. And the judge ordered the district to send him to a private after-school social skills program to give him an equivalent experience as non-disabled kids. And the judge's argument was that, you know, the judge's reasoning was that it's, you know, by doing that for him, you know, that's what he needed in order to receive an equivalent benefit as a non-disabled kid. So for him to be able to spend the after-school hours engaged in learning activities required intensive one-to-one ABA-based, you know, social skills activities, and that was fun.
But that could have been provided by the school district.
If the district would have
Could
offered
have.
it, that would have been great. They made the mistake
Why?
that a lot of districts make.
Why wouldn't they?
Or I don't know if they obviously they didn't know it was a mistake beforehand. Their argument wasn't, we're going to provide something else. Their argument was, we didn't have to provide anything because this after-school program was operated by the Y. It was in
you
the
left
school
that out.
facility.
It wasn't
operated by
school
the Y.
sponsored.
It was school sponsored because it's in a school facility and it's advertised. It was included. We had, like, this is back like how. in the
Yeah, I
early-
guess, but again,
But that's just like they rent space.
The school advertised it on their website. They had it on flyers.
they got
with
involved.
this
All right, so they
idea.
had like a partnership with the Y.
So that was
Okay.
actually a side question I was going to ask is what?
God bless you.
Bless you.
What about school events, perhaps held by the PTA, PTO? I mean, what is the responsibility there of the school to provide access to those that's, you know, accommodating somebody who has?
God bless you.
The 504 and the ADA apply to schools and all school-sponsored activities. I think the PTA, PTO, and who else?
No, just that's what I said, PTA.
And, you know, that they're probably tied closely enough with the district. I don't know what the actual test is. In that case that we had, it was real easy to show that the district was providing this program. It was just because they were using the Y to, you know, staff it. You know, it was their teachers that were wandering around the room. I don't even know what the Y's role in it. This was 15, 20 years ago. But a PTA type activity, I think, would be tied closely enough with the district. I'd rather, you know, I'm trying to think of anything that's done, you know, through the school that wouldn't be considered a school sponsor activity. I can't think of anything, but it might be because I didn't sleep real good last night.
Well, in that case, the test would be whether or not the event was on school grounds.
Yeah, if they use school facilities, then, you know, it's very easy to make that argument. If the school provides transportation to it, if it's off of school grounds, if the school's staffing it, if the school's promoting it through their media, you know, whether it's the website or written flyers or, you know, tweets or
Like
whatever.
trunk or treats.
That's what I was.
Yeah, I know.
So special education goes in the IEP.
Right.
Related services go in the IEP. We have another category of services. They're supplementary aids and services, which tie into the idea of least restrictive environment. Least restrictive environment means that your kid is going to be educated to the maximum extent appropriate. So maximum, right? That's different than IEPs, you know, being reasonably calculated to confer benefit. Now we're entitled to maximum opportunities to interact with non-disabled peers and, to the greatest extent, educate kids in the settings that they would attend if they weren't disabled. So in their home school with non-disabled kids, unless the kid can't be educated appropriately in that typical non-disabled educational setting, the general education environment. LRE, least restrictive environment, LRE, right? And appropriate are parallel. Yeah, you can't do that because I'm holding stuff. That's parallel. The least restrictive environment requirement is in addition to the requirement that the IEP be appropriate. Way too often, I'm sure not Bayonne, but districts are given, they're given all this crap by the state. The state, this is an area that if you want to go after the state, they're just sitting ducks. That they've turned the screws on school districts to put kids into less restrictive settings because New Jersey's numbers were out of control. They were, what, number 49 out of 50 in terms of the degree to which they included kids with disabilities.
We were in the cohort.
Were you?
Yes.
Yeah, so.
We made it out in a year.
Cool.
And it was tough.
Right.
And the state said, this is what you have to do. Okay, do it. And we're like, okay, so everybody jumped in the pool. And it was successful to a great extent, but it wasn't for everybody. And we kept some pull-out resource rooms, and we certainly kept our self-contained classes. We were like, okay, when the time comes, and you tell us that's going to go away, because that was almost the vibe we were getting, like like self-contained is going to go away. I'm like, really? And it didn't, and I don't believe it ever will. But yeah, we were in the cohort.
And we've done a lot. My office with horrible name for an organization, but the Association of Schools and Agencies for the Handicapped. They want to hang on to that name because they think ASA means something to all of you. And I'm like, lose the name because nobody knows you anyway. But it's the umbrella organization for the private schools that serve kids with disabilities, mostly approved private schools that are approved by the state. And we did a comments, I guess, for the legislature about, and for the Department of Education, that laid out the histories of special education in New Jersey, because you have to trace this back to the early 1900s. New Jersey started developing this network of private schools for kids with disabilities before any other state did. Katzenbach School for the Deaf being a great example. And over the years, before 1975, when the IDEA came along, the resources were put into that model that were going to serve kids with intellectual disabilities in separate settings, but the separate settings were really, state of the art for the time, and the kids got really intensive, specialized programs there. And the school districts, because they had those resources available, didn't have to develop the in-district resources to be able to serve these kids. And over time, a huge disproportionate amount of money is put into private schools versus helping public schools be ready to educate these kids. And then the IDEA comes along in 1975, and Jersey continues building these schools up until 2001, when they published the first version of what turned into their 2008 accountability regulations, which are fiscal accountability regulations. But when you read the regulations, it says real clearly to school districts that if you don't bring kids with disabilities back from private schools, we're not going to approve your budgets. They'll never agree to that. The state would never agree to that. We fought with them, we sued them over it, and we worked out a deal where the Commissioner of Education gave us a letter and saying explicitly that wouldn't happen. But it's still, you tell me, I don't talk to enough district people about this. I just see it from a parent side, that the screws are really turned on school districts not to place kids into out-of-district private settings. And if they do, then they really need to be able to justify it, which I agree with. We don't want kids with disabilities being sent far and wide just because they have disabilities, but you got to give the districts the money to educate them right in district, because if you don't do that, then you're just setting up this recipe for disaster, which it sounds like you're on top of. So,
well, I do have to say this. We're a district of classified students without speech. I'd say 1450, I always go 1450, 1470, pre-K 12, and we only have 48 children out of district.
Yeah.
So we educate them here.
Right, and I have
regardless of the funds, we do educate them here. We have good programs. Sometimes it goes against us, and graduation rate, all that kind of stuff, but we have a big 21 program, which is, great on one end, yet the state is saying, well, you're not meeting the graduation rate, because it goes against us if they're here after 4 years of high school. But now they rectified that. So any child who's here after their 4th year, regardless of their age, they're considered, if they didn't graduate. So it goes against Bayonne to have anyone here 19, 20, 21, but we do it because we have a large 18 to 21 population. But now they've just recently caught on, and it's not going to go against districts that do choose to,
I'm glad to hear that.
Yeah.
I hadn't
So are
heard
we,
of that
because we weren't
to
gonna
graduate
not
kids.
do it.
Right, that's not cool. What got me on the least restrictive environment tangent was supplementary aids and services. And the only reason I took that side course into least restrictive environment, supplementary aids and services are services that your kid doesn't necessarily need in order to learn. If your kid needs them to learn, they're either special education or related services. These are services that we're going to provide to a kid to be able to move him to a less restrictive environment. I am blanking on good examples.
Assistive technology.
Thank you, Jason, comes through, right. So both of you are on the same page. So if your kid is able to participate in a regular education class, if given the right technological tools, a kid with a disability that affects his writing, if you're going to address the writing skill itself, then that's special education. But if you're going to do it to allow the kid to participate in the regular education classroom, it becomes a supplementary aid and service. I don't think you care. There's no legal reason for you to know whether what you're asking for is special education or supplementary aids and services. I just felt like I needed to say it, which I just did. Any questions?
Since you opened the can of least restrictive environment, you did mention the maximum. How's the wording go? The maximum, something about the maximum time with non-disabled students. So in this district, for example, we have pre-K that's full day now, but we also have pre-K that's half day. But so I'm just trying to understand it. I don't want this to be like a personal question to my specific situation, but because we have this kind of, what was the new pre-K called? The lottery one that they just did.
Oh, well, that's under a state grant.
They got a grant to do full day pre-K, but it's only offered to a certain number of kids, and not all obviously they're not all in special education.
No. So the grant that we applied for, it came out, you had to apply pretty quick, and the superintendent wanted to apply, and we were actually fortunate enough to grant the money, but it only allowed the district to open 5 full-day pre-Ks. They were very specific in the guidelines under the grant, so there could only be so many children overall. There had to be at least one classified student in the gen ed class, because I think the whole point of the grant was to foster best practice inclusive pre-Ks without the special ed teacher as the co-teacher. I'm just saying, so when we were granted, then there was a lottery, certainly, to all the pre-K parents, if they chose to go for, because we're half day in general ed here, to do the full day. And then we had a separate confidential kind of lottery that any special ed parent of a child who was already in our half-day inclusion and wanted the full day, with the understanding that it would be by a gen ed teacher, who, by the way, all of our gen ed teachers who are in those settings are dual certified. They're special ed and gen ed. Yes.
That's awesome.
I know, because you pulled my special ed teacher out of her class.
Well, no, I didn't.
No, not you personally. But
Yeah, I know, because I know. Some of my special ed teachers went because they were dual certified. So that's
I'm just
the
wondering.
specs of what happened. Now, what's your question?
Well, you also missed you also missed the paid full day program.
Oh, yeah.
I couldn't even give you the details on that, because it's not.
Barry. parents.
I just
buy-
happened to be involved in the other grant because it was a special ed, children were gonna be included in that. As far as yes, there is one pre-K, parents can pay for a full pre-K.
And that sounds like a great opportunity for Kim to really show the district who's in charge here, because you want your kid in that program.
No,
it's
what are you
lottery
asking?
and
Keep
whatever.
talking. Listening.
Yeah, then my answer, and I'd have to know a lot more about, before this becomes something that you do anything about. So if you want to talk like afterwards or whatever, I'm happy to. But I'd be curious to see how the district's attorney, not the administrators, but legally, how they legally support an argument that if a kid can be shown through the IEP process to require that kind of placement, and the district has it, we're not going to let them in because it's a lottery.
Right, we're not going to let them
At
in
the
because
same
it's a lottery,
time-
or because we just simply do not offer more than half day to a quarter of the, or 3/4 of the population.
It gets messy.
Pre-K.
I mean, would a district have a legal standing when it's a state grant and those are the specs? I don't.
State law kind of falls by the wayside when we're dealing with a federal law,
Right.
which is the IDEA. But the other side of the coin, and a lot of districts started inclusive pre-K programs because of a decision from our very high Third Circuit Court of Appeals that parents sued their school district because the district wouldn't place the kid into a private preschool of non-disabled kids and send a special ed teacher to the preschool, which, who would think that you're entitled to that? But the court said this could be something that kids require. The court didn't order it for that particular kid, but the court said there's no reason why the team shouldn't have that as an option, which opened the door for us on the parent side to come into districts and start demanding that they put kids in the private preschool. So lickety split. It wasn't just me; it's all the parents' attorneys that jumped on that bandwagon. That was a 1995 decision. So this is like the early 2000s. What do you call the first decade of the 21st century? It's not the aughts. Aughts.
Yeah.
Okay, so the aughts. AUGHT.
AUGHT at aughts.
Okay, so that's when this was all going down, and preschool's messy. Like giving kids inclusion's
It is.
messy. Like in New Jersey, it sounds like Bayonne's got an approach that is working, and I'm not gonna. I don't have any reason to suggest that it's not, but the difficulty with inclusion, comparing again, like going back across the river, it's been so useful for me to see how other states do it. And Pennsylvania never had that network of private schools in the first place. They always had the public schools supported by county agencies called intermediate units that support the public schools and educating kids with disabilities in district, and it works. So in Pennsylvania, we do a lot of inclusion cases. In New Jersey, we do a lot of cases to get kids placed out of district, because in both states, that's where the services are. In Pennsylvania, when a district says we're going to put your kid out of district, it's usually something that you don't want because the private schools suck. In Jersey, we've got these awesome private schools that parents see and they fall in love with, and they think, this is what my kid needs, and sometimes it is. So if anybody wants to talk inclusion, I love it. I don't get to do it enough in New Jersey, so we can hang out afterwards. What else do I have to say about IEPs? That you have to go back, review them, revise them, at least once a year, more frequently if needed. Districts have to have an IEP meeting anytime a decision has to be made about whether your kid will or won't get something different in his or her program, because the district isn't allowed to make that decision. If you want your kid to have the horseback riding therapy, you ask for it. It's not okay for the district just to tell you, no, we don't have to do that, or we're not going to do that, or whatever. It's got to be done through the team process, which means everybody's at the table and you get a chance to explain why you think it's necessary and why you think it's appropriate, and the team should do it. And they're under, at least since March, under this new Supreme Court decision, they've got to explain to you why they don't have to in terms other than, we don't do that here, but Kim would never try that. And you know, that process of making decisions in meetings, if you want, you know, if you make a written request for a change in your kid's IEP, it doesn't have to say, please change my kid's IEP, you know, on page 4, just, you know, please give my kid another session of speech therapy. The only way they can do that, the district can do that, is to have an IEP meeting, and they have to do it within 20 days of getting your request, if it's a written request. If you ask for it verbally, that 20-day clock doesn't come into play. So if you're having any difficulty getting into the table, make the written request, and I would guess that you're not going to say no to the meeting.
Does that
Districts
apply to
generally
dropping
don't refuse
services?
meetings.
Or just adding?
Both. You know, and anything that's, you know, requires a change. There is the option now of using the meetingless revision, you know, that they can ask you if you consent to change the IEP without a meeting. And if you consent, then it's fine. If you don't need to have the meeting, you don't need to have the meeting. But you know, historically, it's been the case that districts make decisions outside of the meeting. And again, that's a procedural thing that if they do it, you're not going to win just because they broke the rules on that count. But if you can show that it affected your kid negatively, then you know it can become worthwhile. Yeah. Oh, good. I didn't even think about the middle part.
I think I have a question. I'm not even sure how to like put it all together, but I guess at the annual, and I don't even know who it's directed towards. It's just a question. So at the annual IEP meeting, you go back and you revise and you go over all of the modifications and everything that's on the IEP for the following year. Come the following year, September, you have a brand new teacher. Now the teacher has, yes, all of the objectives, modifications, and so on and so forth. But they don't really know your child. And sometimes there's things that the teachers will figure out about your child that you could simply just kind of tell them. But I feel like it's just too much and not always necessary to put it in an IEP. And usually the teacher will reach out to you once they start to see that there's issues or something's not working. At what point, and Sarah, I know you said that you can request an IEP at any time, but would it even be necessary to ask for an IEP meeting, or would it just simply be a meeting with the teacher at the beginning of the school year? Is that, like, how appropriate is that? How early should you do it? Should you ask for your caseworker to be there? Because I know that they're so busy with the workload in Bayonne. So is it appropriate to ask for the caseworker there? Is it something that you can put in the IEP meeting that you would like to meet with the new teacher from the new year? So I don't even know what my question is.
No, there's 11 of them there. That's
I know, I was counting them.
It sounds like Kim, I was watching Kim, she started like getting excited, so go for it.
You certainly have every right to request a meeting with your child's teacher. That does not have to be considered an IEP meeting.
So it's not a formal IEP meeting?
Right. Meetings happen with parents and teachers all the time, and teams, and we don't even know about it.
Right.
Because that's just something that any parent would do for their child. You also have the right, certainly, if you feel, to request a child study team member to be with you. You can do that. Probably there won't be any change necessary to the document, but if there is any, then you would have to reconvene, reach out to the team and have an IEP meeting, because if your parent conference resulted in what you kind of think is going to be a change in something in the document, then yes, you can either reach out to the team. If they agree, they can do a revision correction and send you an amendment, or have a meeting with them officially to change the document.
But I think, and jump in if I'm wrong, but I think the point is, if what you see, for example, like in June when we do an IEP, you know, my daughter, she's 3. I mean, things change between June and September, like, drastically. So if her goals no longer made sense, come September, I would totally call for a new IEP meeting and update the goals. But if I just want to tell the teacher that she responds really well to Daniel Tiger's like lessons, and so you might want to incorporate those in talking to her, then that's just a teacher, hey, these are just helpful things about your kid, how to talk to them, and that's my.
That's a little similar to what's your name? Anne's question or comment before, that the district isn't writing in the IEP necessarily the magic words for Norton Gillingham program, but she's getting it, which is fine. There's no reason not to do that. And I had a case over the summer, Pennsylvania thing again, that most of my stuff's Jersey. I don't know why all these examples are making me seem like an out-of-state person. And I told you I live in Philadelphia, so that doesn't help either. But a first grader with Down syndrome, that it was an inclusion case, but the teacher got on the witness stand and found all these things she's doing that don't match the IEP, but it became clear after talking to her for a while that they were all really good decisions she was making. At the end of her testimony, the hearing officer took me aside and asked me if I really wanted to continue with it. We had a count in the due process petition that the district wasn't complying with the IEP, and the hearing officer actually suggested to me that I should take that away and pull that out, because what was happening, it became really clear to everybody that the teacher was going above and beyond what the IEP required and doing things better than the IEP would have, which you can't sue them for. You can, but it's going to be really hard to win.
Right.
So if you have and that's what good teachers do. And in my experience is usually teachers are good, that they're going to find the specific ways that work with your kid that didn't come up in the meeting because that teacher didn't have her or his particular gifts to offer during the process. But at the same time, it is that safety net that if they deviate from the IEP in a way that you can show it's not helping your kid or is harmful for your kid, then that is something you can pursue, and that happens all the time with districts not writing one thing in the IEP and then doing something different. Did you?
I have a question. It's a specific New Jersey question.
Okay. I do know.
Is there a restraint policy in New Jersey, and how does it factor into the IEP?
Great question. Not yet. There's one in the legislature now that is under consideration. I got a copy of it from Autism New Jersey that I have to give them comments on by January 26th, I think, is my deadline. And I haven't read it yet, so I have no idea what it says. But Autism New Jersey's initial take on it was that it's a good start. They helped write the legislation in the first place, and now we're going to go over it with a fine-tooth comb. But there will be legislation. There's not right now, but
what to do until then?
Any seclusion or restraints have to be listed in the IEP. What the laws usually provide are that there's an initial high hurdle that a district has to get over to seclude or restrain a kid in the first place, and then very frequent ongoing reviews of whether or not it's still required. So, there's a school in Ohio that did a session on this stuff at the last national autism thing, and I think theirs had to be reviewed like every 14 days, every 2 weeks, calendar weeks, not school days. The Pennsylvania thing, it starts out, it's every 10 days, but then after 30 days, it's every month, and then it turns into every 45 days. And I'm guessing that's what's in Jersey's, but I haven't read it yet. They sent it to me like just before Christmas, and then I went to Puerto Rico.
What are they looking at every 10, 30, or 45 days?
Whether it's still required. It's
to be in the IEP or to...
Whether the kid still needs it. They just don't want kids being put in those situations without a continuing justification that it's necessary, because the common wisdom is that you don't seclude or restrain kids unless you have to. And
so if the child just, let's say, did not exhibit the negative behaviors, no longer requires, we use handle with care, training here in the district, so we do have PRT, and it is written in the IEPs. But what would happen if something then occurred extreme on day 47? And now it's no longer part of the document.
Right, every statute that I've seen, and they've also dealt with them in the adult context, with involuntary commitments and stuff, and they always have an escape hatch that, agencies, whether it's school district or otherwise, have, some initial period that they can respond to an emergency situation and then fill in the paperwork later. So, in New Jersey and Pennsylvania for involuntary commitments, it's 72 hours that you can, have somebody put into a psychiatric hospital for up to 72 hours without anybody saying that the person's dangerous to himself or others or herself and others, which is pretty extraordinary if you think about it. But you could do that to me if you wanted.
I was going to ask you to do that to me, actually.
Yeah, it's a nice vacation.
It's a nice vacation.
So I'm not sure. I think you do it case by case, and if you think your kid is being subjected to excessive seclusion or restraints, then definitely document it, and hopefully you get a response that the district will work with you to either convince you that it's necessary or you convince them that it's not, or something in between. It's not an answer. But,
We'll look forward to the autism.
when I send Sarah,
Yeah.
I have to see if A&J is cool with me sharing this. It wasn't published, the draft that they got. So I don't know who the person was in the assembly, came from the assembly. I don't know what assemblyman did it, but if they don't want to share it, then I can't do it. But if I can, I'll throw it in that email I send to Sarah.
I have just a quick procedural question. When I've heard that, I've been told anyway, that you can record your IEP sessions. Is there? I mean, do they have to? I guess they how do I put this? Like, in terms of consent on their part, like I think, do you guys have a policy about recording in the IEPs?
Just have to provide notice beforehand.
Right.
That you're going to record.
Right.
And maybe that's sort of a PSA to everybody else, is make sure if you're going to ask for anything like that, that you tell them in advance. I know I asked to do it in mine, and they said they couldn't do it because for me to record, they had to also record at the same time.
Yes.
And their tape recorder was broken.
And you told them that day?
Yeah, I walked in the door
So
saying, my husband's not here, I'm going to record this.
Yeah, so in advance, they will come.
Yeah.
We certainly have had parents and guardians tape without divulging, and then have learned after that can't be used in court or because they wanted to kind of, but we can't tell you no, but we tape at the same time.
So in that situation, what would have happened? Because their tape recorder was broken. If I'd insisted, would they have rescheduled, I guess, the meeting?
Yeah.
Okay. So that's the risk you take if you don't tell them
I mean,
in advance.
I would hope they would have. I always say yes, but I would hope they would have, because then
we got around it because they let me do Facebook Live, so it was like a live.
Right. Also in the past, but that kind of didn't work out on an occasion, so we stopped. We've asked a parent to provide a duplicate copy of the recording in good faith.
Yeah.
And then when that didn't work, we were like, okay, we'll just record on our own. So this way there's no, but yeah.
And what I tell parents is, that it's a courtesy that you owe them to let them know that you're going to tape and let them know beforehand. And they will let you, and they often will make their own tape. And if they make a tape, then you're entitled to a copy of that. If they want a copy of your tape, I would suggest give it to them. The less you do, and this is just generally, again, it's not because these folks are here. Whatever they ask you to do it unless there's a really good reason not to. Because I get way too many parents that don't do things because they don't have to, and that doesn't fly with judges. They want to see, a back and forth, even if you're making all the effort, which this isn't Bayonne, it's somewhere terrible. that you're making all the effort, they're not responding, but you still have to make those efforts, because once you stop, it's a lot easier for them to make you look uncooperative than it is for you to make them look uncooperative, because they are a group of people that would all have to be colluding and working together to be uncooperative. Judges don't want to go there unless they have to, but it's real easy for them to just drop a couple of examples of, we asked the parent to give us a copy of the doctor's report, she never gave us the report. We invited her to the meeting, she never called us back, or he never calls back, and before you know it, you look like public offender number one, and not Bayonne, but their attorneys know what to do with that. Who's your attorney? Let's just not go there.
Do I know? Yeah, I do know.
Oh,
Who do we use after Zazie?
Oh, what, Jamie?
Oh,
No, okay.
Jamie has his own firm now.
Does he really?
Yeah, we'll talk.
All right.
So we have Mr. Merriman.
I had Jamie years ago, and I got to ask,
Yes, I know.
I had this giant thing in Bayonne. The superintendent was a McCabe, and the mayor was a McCabe, and the police chief was a McCabe. They were all, it was
Mayor?
two brothers and a cousin, I think.
Andy and Jimmy.
Andy was the superintendent, right?
No.
No.
Andy was the director of special services. Andy. Jimmy.
Okay, right.
Jimmy was hold on.
I might be.
Principal of child study teams before. Yeah, I don't know where that came from, but then he became principal of an elementary school. So Jimmy kind of came out, but out of special ed and became a principal of one of the elementary schools. But they were together in special ed. One was the
There was a couple of them, because I read. I forget
Andy,
how it
Jimmy,
came
and
up.
then
One of them
the brother.
was in city governance, not school district stuff, but Bayonne.
In Bayonne?
Yeah. And,
No, right?
and I just got this picture. I have no
That's what I
idea
was
if it's
thinking, is the
accurate, that you
Smiths.
just have this family. Like in Philadelphia, we have a couple very active political families that kind of own the system. They're all over the place in every appointment.
Wasn't it with Mark and Smith?
I don't know.
Nobody.
The Smith.
Yeah.
Especially this side of the room. So.
You're talking about Smith.
Yeah, it was the Smiths.
Yeah.
Mark was the mayor.
Leo,
Craig.
It wasn't relevant to the case. I just thought it was interesting.
It probably is.
So your question is,
No, I just had this picture of Bayonne being as filthy politically as Philadelphia.
We'll send you a link.
So, it's
okay.
I know.
8:15.
Yes.
wow,
Ira's gotta go to Philadelphia.
before the snow.
So any last questions?
You gonna stick around for a minute for a
Yeah.
second? Okay. And Jay, do you want to?
I brought my lawyer in right away.
And depends on how close this is.
Like instantly.